that's not to say that the lawyers probably thought in their mind or read the law, interpreted the law to give their client standing. I mean, you know, that's how sometimes you establish standing and
Right.
do the reverse. But that was just a question I had in my mind. I mean, it's not determinative of my vote.
Well, I mean, there again, I would be open to a suggestion that you would, you know, the committee would, you know, want to strike that language and you know, use a more broad, more specific language. But thank you for the question.
Yeah, I think it may just be as simple as putting in the word any affected.
Personally agree.
Yeah, yeah.
Yeah. You saw the definition on page 2 of the bill, right?
Yep.
It's pretty broad.
Yeah.
Okay.
Thank you, Mr. Chairman.
Yeah. Don't know that it helps, but it's there. All right. Vice Chair.
Thank you, Mr. Chairman. If I could ask the sponsor series of questions, and I'll be quick. Right now, we're at an all-time record of home values, and the other day when we had the bill, it was 2027, I believe. You've given another 2 years for these large-scale, high-volume companies to sell the property off at a time when values are at a record high, right?
That's correct. I just, after talking and get some input from people, I didn't want to flood the market with the houses. So I think that, you know, if the sell-off is 4 years, that wouldn't, you know, be devastating per se if they did start selling their houses.
And on the flip side, one benefit that your bill does is protect against what happened during the Great Recession, when you had a number of companies that all of a sudden owned too much real estate. When the market went down, they failed and they were coming to the government to bail them out. Your bill protects against stuff like that, right?
That's correct. It's not too big to fail, and I feel like that you know, a lot of these companies, if they did fail, that would be the case again. We're letting them, you know, grow so large that if they defaulted on 300,000 or even, you know, 70,000 houses, the government would have to step in there again and take these houses and do something with them. So. Yes.
And then the wording that Chairman Smith asked about, personally affected or personally aggrieved, is that some kind of amendment is that a friendly amendment if we heighten the standing?
Yes, I would definitely be amenable to that. I mean, obviously, you know, it's a private attorney general provision, so that would be the whole crux of the bill, but I would be open to a friendly amendment.
And
yes.
then you and I and our 20-something colleagues in Gwinnett County worked on tax relief in Gwinnett County. We had about 125,000 homeowners in Gwinnett, and statewide when we worked on that, it was over 1 million. You're saying there are now about 400,000 units owned by these companies?
Yes, in Gwinnett County, obviously, we've had a lot of research on this because we've had several bills this session over this, and Gwinnett County's been hit very hard. And I tell you what, it has done also. These companies, with the amount of money they have and all cash offers, they're paying over what the house is worth, say 50,000 or 70,000. So that affects our constituents, because once they overpay in an area, the tax assessor has no choice but to use that comp, and it's making all of our constituents, you know, that's why we're wrestling with taxes increasing.
And final question, in addition to the bill we voted for today that Representative Oliver sponsored, in addition to you and I contacting the federal authorities this week to invite them to investigate antitrust laws applicability on this, is your bill a step in the right direction that you would continue to get good input on how to perfect it between now and sine die?
It definitely would be. I mean, I think we just can't sit around and do nothing. Obviously, like we talked about, reaching out to the feds and you know, the federal government and doing the antitrust. But that's something that's going to take years, and we just can't sit and continue to do nothing. So I had one representative as I was walking over here. I think it's a step in the right direction, and she had said that we, you know, there again, we just can't do nothing. Thank you for your question.
All right. Representative Momtahan.
Well, thank you, Mr. Chairman, and thank you to my friend, the author of this bill. You know, Representative McConnell, we've had several questions and conversations about not only your bill, but several bills that have been floating around this General Assembly and the House of Representatives. I think we passed out a pretty good measure today House Bill 399 from Miss Mayor Margaret Oliver, Representative Oliver. You know, in those conversations, can you verify that what we've heard in this testimony, that in some cases these hedge funds, these institutional investors, are not even renting these properties? They're just
That's correct. A lot of these investors are just buying them for a tax write-off, and they got really good, IRS benefits for just buying the house, parking their money, and just writing them off. And so, unfortunately, the house just sits empty. There again, they park the money there, and then it just goes down. Obviously the house looks terrible, and it just sits empty and goes to decay in our neighborhoods.
Well, thank you further, Mr. Chairman, if I may. Were you aware of the statistic that has come out that in Paulding County, Georgia, which were a county in the metro Atlanta area, that 83% of the single-family residential rental market is investor-owned?
I wasn't aware of that, but it doesn't surprise me. Like I said, Georgia is one of their biggest, without lack of better words, on their hit list for doing rental property here, and then on top of that, they're obviously doing 100% rental communities, and I'm curious of what those are going to look like in 10 or 15 years as well. So
That's right. And I'm sorry, I should have said institutional investor owned. That is the 21 largest hedge funds, residential hedge funds in the United States. Thank you for your bill. And Mr. Chairman, at the appropriate time, I'd like to make a motion.
Okay, we've still got some questions going here. Representative Oliver?
Thank you, Mr. Chairman. I'm for your bill. 'Cause
Thank you.
we have to do something. And I missed the first hearing, so forgive me if this was discussed previously. On line 70, you talk about a statutory damages in the amount of $15,000, but when we move over to paragraph 2 on line 24, it looks like an additional penalty is that the Superior Court can order the house to be sold. And I'm thinking if that's another kind of penalty that would exceed $15,000 for a whole lot of houses. So I'm trying to figure out if that was intentional to increase the penalty or not, or am I misreading it?
Well, I think that, and I'm there again. I would be open to your suggestions. I'm obviously not a lawyer, and I don't play one on TV. So I think that the gist is that if the houses aren't sold, they would be sold on the courthouse steps. If they are houses that just delinquent, but I would be open to some negotiation as far as those whatever you think would be amendment.
It seems to me that the $15,000 penalty is inconsistent with selling the house and taking all the proceeds away from the owner. Is that your intent?
No, my intent is for them to sell down to the 2,000 house mark in 4 years. That's my intent. So I feel like that would be what happens. But if they try to hedge their bets and say nobody's going to figure out that I own 12,000 houses, we need to make sure that the punishment, if that's the case, and they bring a suit, is something that they think about before they let that happen. I think, like I said, I think that after 4 years they should know whatever penalty's coming, they deserve it. Do you not think so?
I'm for you.
Okay, thank you.
Okay, and Representative Holcomb.
Thank you, Mr. Chairman. I'm supportive of what you're trying to do too. I do have some concerns in terms of the constitutionality of forcing people to sell property that they own, both from a property rights standpoint and as well from a contractual standpoint. Have you looked into that at all?
Well, and bringing this bill, I've thought about that. Obviously, I deal in real estate, and I very 100% with private property rights, and then also very much a capitalist. The problem is with these companies being the capitalists, you can't deal with them. They've got their thumb on the scale with how much money they have. I mean, as far as that goes. But I think we went through. I've started this bill for a year ago, and me and Ledge Council has went through this bill, and we've tried to say, okay, what if we do this or what if we do that? this is the most constitutional thing that we have came up with. You know, it being a, you know, private right of action, I think helps. And then I think that, you know, this is a good bill, and I think it'll hold up.
Okay, thank you. I have a few more questions, Mr. Chairman, if I
Yes,
may.
Go ahead.
Is there any distinction on line 74 between obtains, owns, or possesses? We use those three different words, and they're repeated in the bill. I'm just curious if there's owns is very clear, but is there any particular meaning you're trying to express with obtains or possesses?
Well, the possesses an interest in. So we didn't want to do what they're doing now is to make a shell game for them, and essentially what they do is just set up 50 LLCs and say we're going to put 2,000, 2,000, 2,000. So the extent of that is so we can capture that, make sure they don't continually do that with LLCs, and so you can own or possess interest in any of the houses.
Okay, that's helpful. And then my other questions are on the affirmative defenses, which are on page 5. Ignorance or mistake of law is well known, but some of the others look fairly novel. Can you walk us through those beginning on line 97? Like, for example, reliance on any court decision that has been overruled, even if such court decision had not been overruled at the time. The business enterprise violated it. Can you provide a little explanation around that?
No,
Okay.
I can't. To be honest, I could maybe get you some clarification on that, or if we've got a good attorney in the house, they might could help. I don't know.
Okay. The other one, just in case there's somebody that's listening that knows the answer, the other one that I'm sort of interested in, just some explanation on why it's included, would be the fifth one, lines 104 to 106. It has that would violate the constitutional rights of third parties. Do you have any idea what potential third parties those might be? And the reason I ask is because it's related to a constitutional rights violation, so I want to make sure I understand that.
I'm not 100% sure, but I'm thinking that obviously since hedge funds are, and I could be totally wrong. They do invest other people's money.
Yeah.
So say for instance, if the hedge fund was obviously some parts of it was you have somebody that controls the money and invests it, and then you have a third party obviously that's putting it in. That could be the only thing that I can think of. There again, I could probably get those answers for you.
Okay. All right. Thank you.
All right, I don't see any other questions, so this time we'll move on to those that want to speak on the bill. Betsy Ledford? Oh, back, there you go. Okay. I knew I didn't see her in here. I didn't think she was Betsy Ledford, but that's... All right. That mic's lit.
Good afternoon, committee members. My name is Betsy Bradfield with the Georgia Association of Realtors. Unfortunately, we are opposed to this bill as written, but I really appreciate the sponsor's hard work on this issue, and especially on this bill. I know how much work he's put in this, and we are in complete and total agreement that this is the large-scale corporate acquisition of single-family homes is a huge problem. I just think we disagree on the solution here. You all know how engaged our association has been in advocating for accessible housing across our state, and we have been working for years to find a solution on this issue, but I just don't believe that a cap is the right answer per se. I promise that if we had a solution to bring to you, I would have brought it to you by now. If there was something working in another state, I would have brought it to you by now. Placing a cap on homes purchased won't eliminate the problem, in my opinion, because these large companies have so much money and so many attorneys that it'll take them about a week to split up all their LLCs to get under the cap. And the way that Georgia's corporation law is written is it treats small mom and pop LLCs, small and pop landlords, exactly the same as these large corporations. So there's no differentiation in how they are treated. Therefore, they can just create another one. And currently, as written, an LLC can own an LLC, can own an LLC, can own an LLC. So until we sort of clarify that ownership structure, how are we to know who owns who? We are also engaged in the issue of tort reform, so unfortunately we cannot support a bill that I think makes Georgia more litigious. And if these groups do in fact create more LLCs to get under that cap, then many of these protectionist provisions in the bill that would allow for the private right of action, I fear that they wouldn't even be able to take effect because they would just find another loophole and get under the system. I definitely think we can continue to explore solutions to make it more burdensome for these institutional investors to acquire these properties and remove some of their incentive structure. And I'll happily work with anyone who's interested in doing that and take any questions. But thank you so much.
Okay. Vice Chair Reeves.
Ms. Bradfield, those issues you just mentioned would be revealed in discovery, right? If companies try to hide their ownership under this statute, that would get revealed in discovery, wouldn't it?
I am not an attorney. I'll put, like in Senate Judy, I put my money in my jar.
And in Georgia, they used to call it the Fraudulent Transfer Act. It's now called the Voidable Transfer Act. But, if a company, large or small, does a transfer of an asset to avoid the law, that's fraudulent. I mean, that's something that could be voidable, and the law can ameliorate that attempt to evade the law and to monopolize Georgia's single-family homes. Isn't that true? And
it is monopolized, to your point. It absolutely is a problem. I just fear that the way that we currently qualify the LLCs, that there's no clarity in which one. So how long would it take an attorney to sort through all of this and to do discovery and to require all of this information to prove which LLC owns which LLC? But I'm not disagreeing with you at all that it is a problem. It is a gigantic problem. It is just one that I don't know how to solve.
Representative Montahan.
Thank you, Mr. Chairman, and thank you, Betsy, for your testimony here today. I guess I'm attempting not to get spun around an axle, but I'm trying to understand kind of the whole picture. So you said, I think in your testimony, that it's hard to understand who these shell companies are. Is that correct?
You mean the large institutional investors?
I think what you were saying was a LLC that owns homes could create another LLC and they have shell companies. Is that your contention?
Yeah, so as I understand it, I'm going to name drop like BlackRock. Like, you're not going to go out and go to Georgia corporations and find that BlackRock 1 owns 10 houses and BlackRock 2. They put them all under different LLCs. It's like 123 Main Street, Happy Neighborhoods in Lilburn. And so you go 14 LLCs up and find out that they're owned by a subsidiary of BlackRock. But it's going to be nearly impossible to find just BlackRock owns 15 properties.
So finding the information on these shell companies has been tough, I think you would say.
Yeah, I would agree with that.
So now I have a House Bill 374, that will require these companies to provide information on who they are. But it's my understanding that the Georgia Realtor Association, which you represent, is also opposing that bill too. Is that correct?
We are opposed to House Bill 374, yes.
No more questions. Thank you.
All right. Floor Leader Hung.
Thank you, Chairman. And I don't know if this question goes to you or the author of the bill, but Representative McCollum had mentioned, or actually I think it was Representative Holcomb mentioned lines 73 through 75 as far as business enterprise obtains, owns, or possesses an interest in order to capture concerns and issues that you just addressed. Do you not believe that those lines are enough? And in addition, maybe we also include not only for which a business enterprise or shareholders of a business enterprise, because what you just said made me think maybe there are multiple shareholders of businesses that separately go out and create separate LLCs that have nothing to do with a parent LLC, et cetera. And so maybe that's also a language that we can include. But if we include all of that, do you still think that it will not go towards your concern about having different companies and parent companies?
So I think yes to your question. I think so. The way that the real estate investment trust operate, as far as I understand, is that like they'll create a REIT, and then it'll be they'll own 5% of this property, 17% of this property, 25% of this property. Very rarely do they just own it outright, unless we're talking about some of these like large invitation homes who do own the homes outright, and that's the corporate landlord. So I think the owns an interest in piece, I believe that was in the substitute language. I think the own the interest in, if you're all confident that it captures that, then I believe that I am confident. Again, I didn't go to law school. But yeah, our main concern is just making sure that the people who are actually the targets of this bill are the people who are captured, and to protect our mom and pop landlords who, have, this is their generational wealth. They own 1 to 4 houses in the neighborhood. We want to protect them and go after these big guys who were just destabilizing the market, like Representative McCollum said.
Thank you.
Representative Montahan.
Thank you, Mr. Chairman. Just for the committee here, I was going to look at line 23 through 25 here, and I think this kind of addresses affiliate means any entity that directly, indirectly owns or controls, is owned or controlled by, or is under any other common ownership or control with a business enterprise. I think that pretty well covers these folks who have some type of common ownership.
Okay. All right. I see no other questions. Thank you.
Thank you, committee.
Let's see. Ann McKillop.
Thank you, Mr. Chairman. Mine, while he removed the multifamily, there's still the concern with communities of condos and townhomes. And what happens is you can have one person, not even a company, own 90% of a condo building, or a townhome community that has 10 or 12 units. And those are single-family homes, and you could have somebody own the majority, but not the whole community. And I think we need to see something in there that addresses that. That we could have it. I live in the high-rise where I serve on this board, and we see this where people try to come in and buy. We have active investors that we've restricted from buying in our house because we only allow 25% rentals, which many places also have. One of our owners of several units is a group from the Far East. We also have one unit owned by a childhood friend of Putin's, and that money is in trust. We can't touch it. We can't even pay our HOA dues out of that because it's all frozen because it's in Russia. She lives in Russia and we can't get to the money. Which is, when they told us that, I was like, you can't make this up. But so I would like to see something to do with multifamily may not be the right word because that would include apartments, and that's a different scenario. Whereas when you say single family, people think of a home, individual home, whereas a single family residence could be in a high-rise or in a townhome community.
If I may, Mr. Chairman.
Yes, sir.
So on line 5, it says single-family residence means a partial of real property that has upon it a detached residential structure that contains between 1 and 3 individual dwelling units each of which is designated for the exclusive use and occupied by one family, are townhouses. Townhouses means any individual residential dwelling unit within a large structure that contains two or more attached residence dwelling units constructed of a row, where each residential dwelling unit is designed exclusively for use of occupation by one family, is located in individual lot or partial, shares at least one common wall with the adjacent unit. So obviously that's a very good description of those.
Of the townhome, yes.
Well, and a single
think
family
it-
home.
okay.
Yeah, it says detached residential structure that contains between one or three, well, let's see, I'm sorry, go back. Single family residence means a parcel of real property that has upon it a detached residential structure that contains between one and three individual dwelling units. So it being detached would not be a condo.
Right,
And then obviously townhomes obviously has a description as well.
right. You
So,
do seem
yeah.
to, I
Yeah.
had not read the
Yeah,
final.
no, that's fine. Understandable. Thank you.
But I would like to see something in there about condominiums, because that is getting to be a real problem. There's a condo on Peachtree between Buckhead and Midtown, I'm not sure where the line is, and it is 90% owned by outside investors.
Okay. All right. I don't see any questions for you. Thank you, ma'am.
Got to get those.
Hayden, Stanley? You wave? Okay, thank you, sir. And Sam Olens? Oh, okay, all right.
Thank you, Chairman.
Go ahead.
I represent the National Home Rental Council. It's an organization of companies that have been classified almost as contrary to the American way during this hearing, that principally build subdivisions, not buy houses, but build subdivisions. And without those subdivisions, we would have many people in our region without adequate housing. And with 7% interest rates, there are many people of all ages that are striving to live in a house that could not if it was not a rental house, even though during this hearing, I almost feel like it's a crime to build rental housing. Affordable housing requires adequate supply, and demand is very high. The Georgia Multiple Listing Service estimates that our metro area is short 35,000 to 40,000 houses. So once again, if you tell these companies, don't buy the land, don't build houses, and people are still coming to Georgia, you understand what happens. Home ownership is up in the largest Georgia counties over the past 5 years, not less, it's up. And some of the companies I represent are based in Georgia, reside in Georgia, along with these other companies that I keep hearing are evil. Under this bill, without any evidence of harm, any deception, any wrong activity, they would be subject to that $15,000 penalty. Representative Holcomb, there are so many parts of this bill that are constitutionally infirm. You mentioned at least 5 of them during your comments. It is inconsistent to say there's no evidence of harm, but we're going to charge $15,000. That's not what I think of as good law in our state. Arbitrary restraints are possibly unconstitutional in taking. Representative Holcomb, in particular, you're an attorney, you asked legal questions. I got to assume that the Georgia Constitutional Article 3, Section 6, Paragraph 2 is a problem. I got to assume that Title 22 is a problem, 22-1-5 a taking. I have no idea how what's listed in this bill is not contrary to Georgia statutory law, Georgia constitutional law, and oh, by the way, I respectfully disagree with the sponsor on his determination on the Dormant Commerce Clause. I think that's a huge problem also. I'm not here to say there isn't a problem. I'm not here to say we shouldn't work to solve it. I'm here to say this bill is going to do one thing. It's going to kick a lot of innocent people out of their houses. It's going to cause a lot of companies to no longer build houses for rent. And affordability is going to be less affordable rather than more affordable. I still haven't heard the first argument of how this frankly makes it easier for people to have adequate housing. Arbitrary restrictions, such as the number 2,000, are overtly constitutionally and statutorily difficult. Bill 555 will evict thousands of Georgia residents with no alternative housing. While I appreciate the delay from 2026 to 2029, who's buying these properties? Or do we now live in a country or a state where we encourage folks to have to sell below value because a bill has been filed? If it infringes on private property rights, and it already reduces the low supply of housing, we're absolutely not hurting the middle class that I've heard so much about. Representative Mary Margaret Oliver's $3.99 is a good first step, and we supported that bill. But this bill is a bad step for everyone in Georgia, and I'm frankly taken back by how companies that follow the law are listed in many of our mutual funds, many of our retirement funds, are now in this bill just determined to be evil corporate citizens. And I know that I'm swimming uphill, but I also know that I'm speaking for the vast majority of free market people in saying this bill is a terrible bill, even though I agree with the sponsor that we need to find solutions. Thank you very much.
Okay, you have a couple of questions.
I'm shocked.
Representative Momsahan.
Thank you, Mr. Chairman, and Mr. Attorney General, thank you so much. First time I've met you here in the Judiciary Committee, so I want to say thank you for your service to our
Pleasure.
state.
Thank you, sir.
And I know you've served in many capacities, and thank you,
Thank you.
for those as well. One of the comments you had made was, you have young folks, and I think this is true. I truly do. Young folks that are striving to rent a house that is, that should not be a crime. I think you kind of relate to that. What do you think, and what do you think about your members who are building these homes for rent, who are then subsequently not renting these homes? Is that not also creating some rub or issue of why we're having to be here in the first place?
Representative Monahan, the problem is comments are being made without any research to back it. Why a capitalist would build something and not expect a return on that investment is beyond me. And you're being asked to pass a bill with no research to back up the vast majority of the statistics that were referenced earlier. I'll give you one statistic that I'm really comfortable with. 0.4% of our single-family housing is owned by landlords who rent those structures. 0.4%. Now, I'm not going to deny with you that some jurisdictions like Paulding County have a higher figure than the national average. I'm here to retain credibility, not to lose credibility. But to say that the world's going to hell in a handbag due to build-to-rent homes, candidly, it's not consistent with the facts. And I would love to be part of a process where we work with the Georgia State University, where we work with other institutions of higher learning, and strive to get the facts.
Further question, Mr. Chairman. And I understand where you're coming from. Certainly do. I would contend that renting a home is not the only way to derive value for investors. And I would say that merely owning the home and the property and using the home as a cash sink in and of itself and as an investment vehicle, just as property values rise in and of itself, could be. Further, I would ask your association to make it clear, what I think the members on this panel here in this committee and the members of the General Assembly as to foreign ownership structures, investors, especially those who may or may not derive from foreign adversarial countries. In 2023, $13.1 billion came in to the United States, with Georgia being the number 8 target amongst those foreign adversarial country investors. Now, certainly not every dollar came from a government-owned entity, but I think that given the discussion here on this bill and seeing the money come in, there has to be a level of clarity as to who these investors are, especially when it comes to institutional investors investing big dollars in what seems to be very targeted districts like House District 17 in Paulding County. That would be something I would submit to you as we go through these things, and you can see kind of the posture of folks on this committee. A lot of folks have just had enough, but thank you for your time here.
Representative, I'm all for increased transparency in that regard, but I would suggest to you that at a 7% interest rate, it is approximately 40% cheaper for that family to rent a home than to buy a home. And this discussion largely today doesn't deal with the reality on the ground, that for many of these families, they'd love to purchase a home, but they simply can't afford it. And what this bill is telling them, well, you're not going to rent the home, you're not going to be in the home. But by the way, I'm not sure where they're moving when we have thousands of evictions follow this legislation. And I totally 100% agree with you, sir, about transparency. And I'm not aware of a single person within the National Rental Housing Council that relates to those foreign governments. But I understand your concern, and I appreciate your concern.
Okay. Vice Chair Reeves?
Mr. Owens, thank you for coming. You mentioned capitalism. Isn't it true that monopolies jeopardize capitalism more than anything else almost?
There's no evidence of a monopoly here.
I thought that's something that we could, but evidence, I mean, Representative Oliver presented some pretty compelling evidence today. Representative McCollum gave the statistics about we got now hundreds of thousands of homes that have been purchased in recent years, and you know, I mean, I'll move.
Representative Reeves, where is the evidence? A legislator saying it or me saying it is not evidence. Research is evidence.
I think that people across Atlanta have seen the companies come to their neighborhoods. It's happening in large numbers. We'd be in denial to say it's not happening in large numbers. And I think that
it's
the testimony today has been accurate on that.
No, I disagree. I think
Do you disagree with the fact that 300 or 400 homes have been purchased by large-scale owners of real estate in the past decade in Georgia?
Candidly, I don't have the data in front of me.
Okay.
I'm not there to say you're right or you're wrong, but I think it's important to actually seek data.
Okay. And then if the numbers that are in the bill presently of 2,000 homes, a maximum of 2,000 homes, and having 4 years to sell them off to get down to that 2,000 home threshold, if those numbers are objectionable, what numbers would be acceptable?
So I'm also thinking about the comment that was made about courthouse steps. It is darn right scary for me to think there's legislation that's encouraging capital to be forced to put their property on a courthouse step with no evidence of owing taxes, of doing a single thing wrong, but being subject to a $15,000 statutory penalty. Your question's a great question, Representative Reeves, but that's once again a function of research and study for what the number should be. For me to tell you it should be 5,000 or 10,000 on the day where you're getting ready for crossover, I would suggest to you that these discussions should have been happening over the prior months.
I mean, do y'all want to have a study committee on this?
Sir, I'd be happy to have a committee that literally is based on research with the goal to sit there and protect Georgians. Everyone here wants to protect Georgians. But this bill, in my humble opinion, does not, despite I certainly concur that the sponsor wants to do the right thing.
For Georgians.
For Georgians, right.
Not for outside aid.
For Georgians. I'm a Georgian. But there needs to be research and there needs to be a process. And, you know, candidly, no one went up to me in the last year and said, let's schedule meetings. Let's talk about this problem. Let's discuss it. I would have been happy to have set up those meetings. My knowledge of, remember, this is 555. It's not House Bill 20. It's House Bill 555. I've known about this bill maybe 10 days.
Okay. And this bill maybe, but let me just say, the issue of individual home ownership, there are many in Georgia who feel that individual home ownership has been taken out of reach by large-scale purchasers of homes who are taking those homes off the market. And so I think it is a problem. I don't think we've thrown any rhetoric in there saying they're evil, but I think we're saying it is out of whack and it does need some action. And so we're asking for solutions. That's what this bill is doing.
Is housing affordability a huge problem? Yeah, absolutely. But to put it on 0.4% of the homes that are for rent in our country seems a real stretch to me.
In my area, the homes that are being rented out, you could purchase them at a much more affordable level if they were available for individual purchasers. But the large-scale purchasers are coming in, paying cash at a premium. They are taking those homes off the market before the average first-time home buyer, working people, senior citizens have an opportunity to even go see their lender to get a loan to buy it. That's the problem that we're trying to solve, and we're doing our best. And we're glad to work with the big folks in doing it. But what this bill is saying is 2,000's enough. 2,000's enough. You got 4 years at a record high of home values to sell them off to get down to that level of 2,000. Give the American dream back to individual homeowners in Georgia. That's what this bill is trying to do.
And all I'm saying is it's an arbitrary number, which is a taking.
What's the better number? And the bill says if it's a taking, that's severed. So we're asking you, what is the right number? 2,500, 3,000? We're asking that.
I don't think that's a proper question to be asking when no one's yet scheduled a meeting with my client to discuss the issue.
I mean, if you sell off 1,000 homes at $500,000 each, that's a lot of money. That's not a taking. That's a windfall. That's a benefit.
No, I would totally disagrry with you. If you're asked to do fire sales, that's not a windfall.
4 years is an adequate marketing period at a record high. Thank you, Mr. Chairman.
Thank you.
Okay. Mr. Chairman, a quick comment, if I may.
Very quick. I got more lights going here.
He had said we don't have no data. I referenced Government Office of Accountability, Urban Institute, and GSU Professor of Law. I think that they've researched this. It's not just arbitrary data. Thank you.
Okay, thank you. Representative Kelly.
Thank you, Mr. Chairman. Attorney General Owens, thank you for being here. In the conversation of capitalism and free markets, can we at least agree that when we're looking at a free market system, that reducing supply increases demand and drives up cost?
Yeah, absolutely, sir. But the vast majority of the folks I represent don't buy existing properties. They build new subdivisions.
What about the ones who are doing large-scale purchases? Would you agree that's a problem then, that would have a impact that increases cost?
It may, but once again, we're saying there's a huge problem and we have no idea what percentage of the marketplace that relates to.
A second question, line of question, Mr. Chairman.
Yes, sir.
Since we're debating constitutionality, our state has an antitrust statute, an open and fair competition statute. Now, right now, it largely just revolves around state contracts. Would you agree? Mm-hmm. And have you ever had to defend or prosecute underneath that statute?
No, sir.
Would you think that we would be assured in the constitutionality if we were to move away from the model Representative McCollum has and instead try to modify our state's antitrust statute to move into this? It would be a criminal penalty versus a civil, so that's why I'm trying to see the constitutionality of both.
I think if one were able to make the adequate evidentiary record, then that would be a proper subject of study.
Thank you.
Representative Oliver.
I just had to jump back in. The author of the bill cited this research that I've been developing. It's clearly we have the Urban Institute at Georgia Tech and the geography and the economic development. I just handed to Representative Reeves all the research. It's already been done for us at our taxpayer money. They've already done it, and it's good research. And I don't think we're making up facts here. The map I showed today on the wall was very highly researched. As the districts across Georgia have more than 50% single-family owned by the out-of-state investors.
I'd certainly appreciate you sharing that information with me.
We'll get a copy made.
All right. I see no more questions. Thank you, sir.
Thank you.
And Ms. Apley, you want to join us?
Thank you, Mr. Chairman, members of the committee. Thank you to the author for bringing this bill. I'm here on behalf of House ATL, Enterprise Community Partners, 9 to 5 Georgia, and Presbyterians for a Better Georgia. Those groups and I, on their behalf, have been advocating for years to increase access to affordable housing, to support home ownership, and to provide fair protections for tenants. We strongly support this legislation. I haven't seen the sub, but we understand from the author that a multifamily has been removed because the metrics weren't a good fit. Last week, in the Banks and Banking Committee, Commissioner Nunn pointed out that Georgia has the lowest rate of home ownership of any state in the Southeast. In the Government Affairs Committee last week, I brought forth experts from Georgia Tech, Professor Alora Raymond and Professor Brian Ahn and Professor Taylor Shelton from Georgia State that the author has referred to. And you have in your folders the materials from Dr. Shelton that reflect his research over many years on this issue. You have in your folders not only the maps that Representative Oliver shared on the House floor today from Dr. Shelton, but also a chart reflecting the number of single-family rentals owned by institutional investors broken down by county, and then a second document broken down by your House districts. And you can see, I think numbers were shared earlier about Gwinnett County. You'll see on the county document that Gwinnett County reflects 11,958 as the total number of single-family rentals owned by institutional investors. And Dr. Shelton shares as a footnote to that chart that this was accurate as of January 2024 and reflects properties owned by 21 known institutional single-family residential investors. In addition, Dr. Ahn, when he testified to the Government Affairs Committee last week, identified that the impacts of these massive ownerships are to weaken home ownership, and he cites to his published research on this subject. It raises housing prices, making it harder to buy a home, and cites the research of others. He noted that that they tend to appeal repeatedly to reduce property tax bills 18 times more than owner-occupiers, that the increase in code violations is 4 to 5 times more than individual landlords, that the increase in crime rates for these owners is 2 to 9% higher, and that it decreases building permit activities. In addition, there's research showing that they are more aggressive as landlords, tending to increase the rent more aggressively than smaller landlords, that they're more likely to evict, more likely to engage in serial evictions, and less likely to provide adequate repair and security on those properties. All of that is based on published research that I'm happy to share with the committee. I thank the author for bringing the bill and appreciate your consideration.
All right. I see no questions. Thank you.
Thank you.
All right. That's all the speakers we have on this bill. Who's 18?
Question for the author.
Oh, Floor Leader Hong.
Thank you, Chairman. and I'm sorry, I walked in a little late, so I may have missed this conversation, but when it comes to who may be able to bring an action for violation of this code section, I see that there is any claimant, and then in a different section, I see that the Attorney General or a DA may be able to bring it. Just curious, is based on the intent of what we're trying to get at with this bill, why having an individual bring a suit and being able to get damages of $15,000 and actual damages, etc. What's the purpose of an individual bringing suit versus an attorney general or DA bringing suit?
I think that overall that the private attorney general is going to be the best avenue, because they obviously are going to represent someone.
Private attorney general, is that what you said?
Yes, this is a private attorney general provision that we have in the state. So essentially, that would be the private attorney general, which would be a trial lawyer or another attorney, and they would bring a suit. And I think it would have more teeth into it than attorney general just all of a sudden decided they're going to prosecute these cases. And at the end of the day, these outside entities, the only thing they think about is the bottom line. So if they obviously are going to lose money, they're going to think twice about having more than 2,000 houses. But really, if they do the right thing and we pass this legislation, we won't have any of this litigation. Just sell down your houses. You have 4 years to do it to 2,000. Everything will be fine. So the only reason we're going to have this is if we have bad actors not selling off the houses. So that's
and I like the bill, and I hope that anything that we pass, people do what they're supposed to do. But unfortunately, they don't. But thank you.
Thank you.
Vice Chair Reeves.
Is that private attorney general landscape, is that similar like a whistleblower or a key tam statute, like with healthcare fraud and things like that are out there?
I'll take the vice chairman's advice on that one, but thank you.
Again,
yes.
He's not a lawyer.
Yeah.
Okay. All right, that's all the questions I see. What's the will of the committee?
Motion to pass. Second.
All right, have a motion and a second. Any discussion?
Mr. Chairman, I have 4 brief amendments.
Okay, let's do it.
All right. My first amendment would be on line 30, where it says claimant means A. I would strike A and put an aggrieved. So claimant means an aggrieved person who, and following. That responds to the Chairman Smith suggestion about tightening up standing.
All right. The words in there is 2 words, right? And aggrieved.
Yes, sir.
Okay,
Yes,
got it.
Mr. Chairman. The second amendment is after line 40, after subsection 5B, where it says townhouse, put or, and then add a subsection C, condominium. I was persuaded by the input from one of our witnesses, there are some differences between townhouses and condominiums, so I would add, after line 40, add a subsection C for condominium.
All right. Okay, and move the or, right?
Correct, and renumber the or.
Okay.
Well, I'll put them out there and then have a vote, however the chair and committee wants to do.
I may do them one at a time so that we're all clear on it. But
On line 36, I'm persuaded by Mr. Olin's argument that we could be hindering new neighborhoods and new housing, and so I offer on line 36, where it says real property that, I would add as of the effective date. So it would read single-family residence means a parcel of real property that, as of the effective date, would be added, has upon it a detached single-family structure, townhouse, or condo. That way, what this would do is it would say we are going to free up the existing 1.5 million or 2 million homes in Georgia to be individually owned again, up to a maximum of 2,000 homes per owner. So that's amendment number 3.
okay.
And then the fourth and final amendment on page 5 on line 103, I move to add comma res judicata, comma or collateral estoppel to that list. I think Representative Holcomb was right. If we're going to have a list on there, let's go ahead and add to it. I think what this section was acknowledging is there'd be abundant defenses by the defendant. So let's add res judicata and collateral estoppel. If they've litigated this once before, they don't have to litigate it again. And I like that part on line 105, that the constitutional rights are acknowledged. So if this is a taking, it's a taking. But I've done the math, 1,000 homes at $500,000, that's $500 million. If someone says that's a taking, I think I've got some folks who want to have a taking. So those are my 4 amendments.
Okay. Representative Kelly?
Just a question on a couple of the amendments. I don't know how you want to, what parts you want me to get in to ask those. I mean, I'll second his amendments and then move them towards discussion, or however you want to do those. But
I think we need to, but we did motion the bill, so we're at that posture then.
okay.
So,
I guess first I would ask, what would you consider an aggrieved person, just versus what would be the grievance that a person would have against one of these?
I know in real estate law that is a standard for some claims. There's some law.
And I don't do a ton of that, so that's where I was asking. So that meets mine. And then just for just a add on to maybe for your consideration on your amendment about the condominium, I would just ask for it to be condominium as defined in OCGA 44-371, the Condominium Act.
Let's add that to the second amendment I mentioned. I think that sounds good. So, a condominium as defined in code section 44-371.
which amendment is this going?
The second amendment.
Oh, okay.
On line after line 40.
All right. I'll call on you to get that here in just a minute. 44 what? 71. Okay. All right. This it's lit up quite a bit here.
Mr. Chairman,
yes, sir.
can I ask a question about the amendment?
Yes, sir.
Thank you. Thank you, Chairman.
Hang on. There we go.
The third amendment, so it's my perception that there is a finite amount of land for development out there. And so my question is, would the effective date, I'll just call it, that you had in your third amendment actually defeat one of the purposes of the bill, which is to allow single-family homes available for purchase in the future? Can you maybe just talk to me more about that?
As we were studying the Gwinnett County property tax for homeowners, we learned that there's, despite the fact there have been more homes built and more people move in, there are fewer homes now that are owner-occupied. Thousands more homes that were owner-occupied than just 2019. And so what this would do, those 400,000 homes Representative McCollum mentioned, and whether it's 300,000 or 400,000 homes, it's a large number. Let's diversify that large number. And Mr. Olin said he has, a member who wants to build more build-to-rent neighborhoods. If that's what they want to do with some future housing, they'd be able to do it, subject to any changes in the law going forward. But the 1.5 million or 2 million homes that are presently there, let's end this consolidation of ownership of those existing single-family homes.
Mr. Chairman, if I may, I would just ask the amendments be voted individually.
Yes, sir.
Thank you.
Chairman Smith.
Mr. Chairman, just in all candor to this committee, did a little quick research. Apparently the Fifth Circuit out towards Texas Way has approved of the language already in there about claimants, so the issues that I brought up before, I'll withdraw those.
Okay, thank you. And Representative Holcomb.
Thank you, Mr. Chairman. Vice Chair Reeves, I want to make sure on the res judicata and collateral estoppel that's what you intend, because line 94 and 95 say that the following shall not be a defense to an action. So that would be excluding them. Is that what you're intending?
Oh, yeah. Strike that Fourth Amendment. I thought these were defenses.
Okay.
So yeah, ignorance of the law and things like that are not defenses. I wanted to make sure previous litigation, that's obviously going to be retained as a defense. So strike the Fourth Amendment.
Okay.
Anyway, Representative Evans.
Thank you, Mr. Chairman. To Representative Reeves, I'm not suggesting that we do because it may be somewhere else, but do we need we have a definition for townhouse. Do we need a definition for condominium in your second amendment? Did you already do that?
I put one for condominium. We have the one for townhouse.
Okay, perfect. Thank you.
Okay. All right, and Representative Montahan.
Thank you, Mr. Chairman. And Representative Reeves, I'm trying to follow the rationale here. I think Leader F. Strachan had some questions too, and it may be the same vein. Take me through the application of the change of the effective date, because I'm trying to understand what mechanics look like by adding this effective date to the definition in context of the rest of the bill, of the enabling legislation.
You know what? I'll let the Senate deal with that. I'll withdraw that Third Amendment.
Okay. Thank you.
If they want
All right, well, we're down to 2 now. Do we have any other amendments? Okay.
Did you say amendments, Chair?
I'm sorry? Yes, you have another amendment?
I do.
Okay, go ahead. We can, now. Go.
Thank you. And I had discussed this earlier, but on line 74, after enterprise, insert or shareholders of a business enterprise. That's the amendment.
Second.
Holders of a business enterprise?
Or shareholders of a business enterprise.
All right. Representative Holcomb.
Thank you, Mr. Chairman. I would move to amend line 27 to include the word issuer after trust. And an issuer is a defined term in the code, OCGA 10-5-2, and it's an entity that issues or proposes to issue a security. So it would cover that as well.
Do we need to include the cite to the code section to clarify? Unless, I don't know if it's anywhere else in the code. So
We don't for any of the others. I don't know if Legislative Council is here and can help us with that. I think if we did for any of the others and this doesn't have a definition section, we're probably better off just leaving it.
Leaving it as issuer. Okay. All right. That's fine with me. All right. Any more? Back up to 4. All right. We'll go. Amendment number 1 is line 30. Strike the word a and insert an aggrieved. All those in favor of that say aye. Aye. Any opposed? All right, we got that on. Number 2 is line 40. Line 39 we strike or, and on 40 we insert or, and after that the letter C. Condominium as defined in OCGA section 44-371. Did I get that right?
44-371.
Okay, all right. Any further discussion on that? All those in favor say aye. Aye. All right, we got number 2 in. Let's see, which one was number 4? Shareholders. Okay. Number 3. Amendment number 3 is on line 74. After the word enterprise, insert for shareholders of a business enterprise.
Or shareholders.
Or.
Or shareholders.
Or.
That's what I said. What'd y'all think I said?
Or.
They don't understand northern accents.
Okay. Oh, well, maybe I did say for, so what, or. Gotcha, or. I guess that's my bad hearing. All right. Or shareholders of a business enterprise. That does make better sense. All right. All those in favor say aye. Aye. Any opposed? Okay, we're on with that. And oh. Thank you. Back to line 27. After the word trust, insert insurer or issuer, excuse me. Can't read. All right. Any discussion on that one? Anything additional? All right. All those in favor say aye. Aye. Any opposed? All right. Now I think that's all the 4 amendments. Any other amendments? Now to the main bill. All those in favor of the bill say aye. Aye. Any opposed? Got 1. All right. The bill passes. All right. Thank you, Representative McCollum.
Thank you, Mr. Chairman. Thank you, committee.
Okay. We're out of time. Out of time. Come back tomorrow. Okay, all right. Ladies and gentlemen, I'm at a hard break here. I've got another committee coming in to meet, and I actually have a bill in front of that committee. So we need to vacate this committee. So we are adjourned at this time. Come back at 8 o'clock in the morning.